The European Court of Human Rights on Tuesday ordered Moscow to pay compensation to human rights groups labeled as foreign agents by Russian authorities. The court ruled that labeling the human rights groups as foreign agents violates rights of free assembly and association.
The European Court agreed with the petitioners that the term foreign agent should not be used in relation to non-profit organisations, and in principle should not be used in this sense as it has a negative connotation. It essentially weakens the right to freedom of expression, and it is rather difficult to argue that this term is stigmatising. The use of this term has one goal: to create a so-called cooling effect on the activities of organisations, either to force them to refuse foreign funding completely, or in fact to make their activities impossible.
In 2013, the European Court of Human Rights received its first complaint from a Russian NGO labeled as a foreign agent. The complaints of 73 NGOs were consolidated into one case 5 years ago. Among the applicants are Russia's key human rights organizations, including Golos and Memorial, which the authorities have already shut down.
Even a year ago, such a decision could have had some real impact on the development of the situation in Russia, at least in terms of the fact that there would be no further tightening of foreign agent laws. But if we look at the decision itself, considering the terms when it was made, we informed the European Court of Human Rights in our complaints that the law was discriminatory and that the persecution of non-governmental organisations under this law was of a political nature. But this European Court did not consider it necessary to note this in its decision.
The Kremlin said it sees no point in commenting on the ruling, as Russia recently adopted a law on non-enforcement on decisions by the European Court of Human Rights. Galina Polonskaya, Euronews.